So introduce yourself, please.
Hi, yes. So I'm Donna Lenhoff, and I live in Washington, D.C.
And when were you born and where were you born?
So I was born in 1951 in Chicago.
And tell me a little about your family background.
My parents were first generation Jewish. From their parents were from Russian or Poland, and they grew up in what my stepmom always called the GVS, the Great West Side of Chicago. It was essentially a very Jewish area that many of the Russian immigrants came to, and they felt Yiddish was their first language. They felt it was a really wonderful community to grow up in because people were very caring. Everybody knew each other. My mother's grandparents lived upstairs. It was a warm, cohesive kind of a community. And then when my parents got married after the war, we moved first to the north side of Chicago and then to the suburbs. My parents actually had a pretty unhappy marriage, and they were divorced when I was around 15, and they each remarried quite happily, and I lived the rest of the time I lived at home with my mother and stepdad and step-siblings and biological brother, whom I'm all still close with, I'm glad to say.
Are you the oldest? Where do you fit in that?
I'm the oldest. I'm the oldest of all of them, including all of the siblings on both sides.
What would you say your life was like before you got involved? What kind of things in your childhood and early adolescence led you to think about the women's movement?
I think the primary influence was my mother and how unhappy she was in her marriage. So she always felt that she was economically tied to my dad. She didn't have a college degree at first. She went back to school later, to her credit. And she communicated to me, she probably shouldn't have done, but she definitely communicated to me that she was unhappy and she was stuck. And she felt that she needed to stay married in this unhappy marriage because she couldn't support herself, and that a woman should be able to support herself. And so she, for example, insisted that I learn to type, which even then I knew was maybe not the right thing for me, but I did learn to type, which is a good skill for sure to have.
What led you to actually get involved in the movement? And what year was that, do you think?
It was probably 1970, and it was while I was in college, and my mother and I both read The Feminist Mystique at the same time. And what can I say? It's very kind of cliched. I read it and that was it. I was a convert. Didn't take much. And then I joined a women's group.
At college?
In college, a women's
Where was
consciousness, University of Chicago. Women's consciousness raising group. And so that, meant a lot to me. And then I wasn't sure what I was going to do after college. The University of Chicago, of course, a lot of people go to graduate school. But I wanted to do something that was made more of a difference in the world, I thought, and that was less, in the ivory tower. And a lot of my peers were thinking about law school, and I was interested in law school because, well, for one thing, not a very good reason, it was a career path, right? It was pretty laid out for you, and so I didn't have to think about how to design a career. I didn't think I had to think about it. Turns out I was wrong about that, but and because it was a bit of a groundbreaking thing for a young woman to do, and I was interested in integrating a profession that had previously been was mostly the province of men.
And so the consciousness raising, some of that led you to the law school idea?
Yes, for sure. The consciousness raising, my peer group, my mother's admonition that I needed a career, all of those things. It was in the air. I mean, you know, this was the early 70s.
And so you did go to law school.
I did. I went to Penn. At that time, the class was 25% women on the dot, which we always thought was a little bit suspicious.
What year was that?
So I started law school in 73, graduated in 76.
And did the percentage increase over the time you were there?
A little bit. Maybe it was 30% in the incoming class when I left, but it was not a big increase at that point. Of course, it has now increased. I mean, it's been a lot of years since then. And at Penn, I guess one of the first things I did was also join a women's. Oh no, before that, I actually graduated college a little early, and so I had about 6 months before law school started when I was already living in Philadelphia. And I got a job I knew I was going to go to law school and knew I was going to go to Penn, and I got a job at Community Legal Services, which is the legal service. And I thought I would want to do something like legal services. CLS, if you're not familiar with it, is a very well respected, well known, large, at least it used to be a large legal services program. And at that time, it was really interested in law reform and involving the community in a lot of good ways. And the job I got was actually as a secretary, since I could type. Although poorly, as it turned out. I can't tell you how many errors I made in what they called the divorce unit, because they had so many divorces that they needed to process them. And it turned out that many, if not most, of the divorces involved battering, women who were battered, and also women who were trying to figure out their lives, and how to get away from bad relationships. Well, my parents' situation, my mother's in particular, I think made that an attractive thing for me to work on. And pretty quickly I learned about a small fledgling organization in Philadelphia called Women in Transition. My colleague, who was a paralegal in the divorce unit, had been doing some volunteer work for Women in Transition, and that was designed to provide counseling about the law and options to women who were going through divorce and separation, and many of whom were battered. And so I ended up leaving CLS and working for a summer as a CETA worker. CETA, what did it stand for? It was a government-funded employment program for the summer before law school for women in transition, and I wrote a handbook and some things like that. So I felt pretty engaged in the women's movement already. And then when I got to law school, I joined a women's group, both the women's law group and a consciousness raising group. And I was very lucky to have been in a couple of these places. The consciousness raising group included 2 women who had just graduated law school, so they were 3 years ahead of me maybe. They had graduated from Yale. They had come down to Philadelphia. One of them, because her husband had gotten a teaching position at Penn. I don't remember why the other one came. They were very close friends, and they had been involved in writing, as law students, in writing an article on the legal implications of the Equal Rights Amendment with a law professor at Yale whose name I'm blanking on, but their names are Barbara Brown and Ann Friedman. You may be familiar with them, and if not, somebody should interview them. Barbara's here in the Washington area now, and Ann, I believe, is still in Philadelphia. So they wanted to do something with women's law, and they ended up creating something called the Women's Law Project in Philadelphia, which they were setting up right at this time, at the same time that I was in this CR group with them. So they were very influential in my thinking about what the law could do for women, and about sort of the legal underpinnings of equality and what did equality mean. So I knew I was really interested in that. Of course, Barbara taught as an adjunct. She taught the first women in the law course at Penn, so I took that. And then there was no job at the Women's Law Project when I graduated law school. But I had been lucky enough to, Penn at that time had a program with what was then called the Center for Law and Social Policy here in Washington, and it was a semester-long program where you got credit for coming down to Washington. There were seminars given. This was set up originally when the center was first set up, and it was a real funding stream because the law schools that were involved, there were 5 law schools involved that supported, it provided some of their tuition money they sent to the center for providing these services to the law students. So I made some great friends there and some great professional contacts, and in particular, the Center for Law and Social Policy at that time had a number of different projects, and one of them was called the Women's Law Project. Women's Rights Project. What was it called? The Women's Rights Project, which was headed by one Marcia Greenberger. So that's when I met Marcia. It would have been 1975. I didn't work directly for her. I actually worked for a woman named Lois Schiffer. At the time, there were 3 lawyers there. And I guess, so that was 75. I guess the Law Center was started in 71. Is that right? Something like that. So, there was an enormous amount that she already was able to have 3 lawyers on staff, plus she had probably 5 or 6 law students more every year through this program. So it was already quite a going concern, and that really launched my realization that one could have a career in this, and not only that, but one could have a career doing this work in doing public policy, affecting public policy, not just litigating. I'll try to tell this story
Please.
quickly. Marcia had a meeting at the FDA, and she invited the law students to go with. It was a big meeting, and with a lot of people, so we could sort of sit in back. And I don't even remember the topic. It might have been whether IUDs are treated as drugs or medical devices. Better for women to have them treated as drugs because they'd be more regulated. But it might not have been that issue. Marcia might remember, I don't know. Anyway, we got there. We actually were a bit late because we had to drive to the FDA, which at that time was in, I don't know, still somewhere in Rockville or someplace, wherever it is. And but we walked in, and Marcia sat down, and in her very quiet way, she began asking some questions, just inserting a few questions into the conversation about, well, what if it was done this way? What wouldn't the implication be X, Y, and Z? Again, I have no recollection of the substance. What I remember, though, was the way, slowly, but not too slowly, I mean, quickly enough that, I mean, how long is a meeting? An hour and a half at most. So, within the first 10 or 15 minutes of Marcia doing this, pretty soon the whole room and the whole conversation was just responding to the points she was making. And she clearly had a concept of how the statute worked, how all the different sections of the statute, the FDA statute, worked together, that was pretty influential. And I mean, there was no resolution at the end of this meeting. There never is. But my impression was there was no doubt but that she had made a huge impact on the officials thinking about how to regulate this product and what the legal structures were, that, how it worked, how the law could and should work in a way that made the most sense. Don't know. We should also ask her what happened, because since I don't remember the topic, I wasn't even working with her. I was working with Lois. So it was all, for me, this was all about the power, the dynamic in the room, really.
And what were you working on with Lois?
We were suing the Army, the U.S. Army, I was working almost exclusively on a lawsuit against the U.S. Army for restricting so many military occupational specialties so that women couldn't work in them because they had something to do with combat.
I see.
So, I mean, you all know the end of the story on that.
Why don't you say what the end of the story is?
Well, women are now able to, the number of military occupational specialties that are restricted to women, or women are restricted from, is minuscule. I don't even know. I guess there's still some sort of combat exclusion, and of course women are still not drafted. And the Supreme Court has made it clear that sex discrimination and even other kinds of discrimination in the military, if it's a military or national security related purpose, there will be a lower scrutiny given to it, or a higher. If the scrutiny is the same, the justifications are given greater weight in a military context. So we're still not there. It's some question about whether the Equal Rights Amendment would get us there.
So 40 years, we have made progress.
Yes, and women in the military is the participation of women in the military is obviously much, much greater than it was then.
Mm-hmm. Okay, so we're at the end of law school.
Yes, so okay. I'm at the end of law school. I have finished this semester. I want to come to Washington to work on public policy, preferably on behalf of women. Again, there was no immediate job, but so I came to the Justice Department because it seemed like a good job. It was kind of like a clerkship. I was in the antitrust division, but in the honors program, I figured I could parlay that into something. And after about a year, I began volunteering for a group called the Women's Legal Defense Fund, which I'd been familiar with when I worked at the Law Center, because the Law Center had represented the Women's Legal Defense Fund on a few things. Since at that time the Law Center didn't itself take positions, so I don't even remember what the things were, but
This is the Law Center that was at class.
At class, right.
At the Center for Law and Social Policy.
Marcia, right. Marcia. What's now the National Women's Law Center.
Right.
And then was called the Women's Rights Law Project.
Mm-hmm.
The Women's Legal Defense Fund was setting up a shelter for battered women, and I wanted to do some work on some feminist thing with my pro bono time, but I didn't really want to do more legal research and sitting in the library, which I did all day, every day at work. So I wanted to do something that was a little bit more hands-on, and the Women's Legal Defense Fund had a task force on abused women setting up a shelter for battered women. So I joined the task force. It was pretty early, and I became quite active on the task force. I ended up, this is all while I was working at the Justice Department, I ended up being the official representative of the Task Force for Abused Women on the Women's Legal Defense Fund's board, because the Task Force for Abused Women was not mostly lawyers. The people who were working on setting up a shelter, didn't have to be a lawyer. And the person who'd been representing them but they needed the imprimatur of the Women's Legal Defense Fund. It was also a way to help raise money for the task force. Foundations in the area were familiar with the Women's Legal Defense Fund, but not familiar who was this task force, so that's why they wanted to be part of the fund. And the fund had discovered, just as I had discovered in Philadelphia some years previously, that most of the calls that they were getting to their domestic relations hotline really were about abuse. And so they realized that they needed to deal not just with the legal issues arising from abuse, but also with some of the very day-to-day practical issues, as in getting women to someplace safe. That's, as I understand it, that's how it happened. Because this relationship had already been created by the time I got involved. Anyway, the person who had been representing the task force on the funds board was not a lawyer and wasn't able to answer the questions that the fund was raising about little things like liability, insurance, things that, because of course the Women's Legal Defense Funds board was all lawyers. And in fact, the woman who was representing the task force on the board would come back from the WLDF board meetings all flustered. Oh, they don't want us to do anything. There was sort of an us-them relationship being created, which was not healthy and not good for either organization. So I ended up taking over and was able to explain, to translate to the non-lawyers what the lawyers wanted, and to the lawyers how the non-lawyers were looking at it. So I was essentially on the board and became quite close with Judy Lichtman, who was then the exec. She was at that time still part-time, although she still worked full-time even then. So that would have been 1977, probably. I think she started at the fund in 74. Before that, they didn't have any full-time staff, any staff at all. Anyway, in 78, Judy got some grants to hire her first staff attorney. And I applied, and voila, right, and kind of the rest was history. So I worked at the organization for 23 years. Starting as the first staff attorney of the Women's Legal Defense Fund, doing a lot of local service provision, legal service provision, as well as I continued to work with the shelter for battered women, which ultimately became my sister's place and spun off from the WLDF when it got its own funding base and had developed its own relationships with funders, etc. And is still quite a good going concern. So went to their big anniversary. Would it have been their 40th anniversary? Yes, I think, quite recently. So I started there. The organization changed a lot. The work changed a lot over those 23 years. When I left, I was the vice president and general counsel of something called the National Partnership for Women and Families. And we didn't do any local service provision.
The name changed.
The name changed and the mission changed. Over time, the mission evolved, and there was a big change that was in connection with the name change.
What was that?
It was from doing local service provision to just doing national advocacy. The shelter, I think, had already spun off, but there were still some other local service provision programs. There was, for example, there were a couple of different counseling, telephone legal counseling programs that volunteer lawyers for the Women's Legal Defense Fund basically did. So those were spun off to different organizations, some with better success than others. I mean, I think there's still some gaps in local service provision about women's legal rights. Some things became less important. For example, there was a name change committee.
I was part of
You were part of that. I'd forgotten that, Judy. That might have been how I met you first. I don't know. There was a credit discrimination committee, which was never really busy, I think, a lot because women don't know why they're denied credit, and they think it's because they have lousy credit, and don't realize that perhaps a man with similarly lousy credit would have not been denied credit. So I don't know. There wasn't a big demand. My sense is that the Equal Credit Opportunity Act has made a difference in banks and other lenders' actual practices, and that they realize that women are a huge market and that they shouldn't be turning people away because they're not married. I mean, certainly the more egregious practices have stopped. Whether there are more subtle practices, probably there are. I haven't followed that issue. So those two, we weren't spun off. They were just left to, the demand was not very high to begin with. But the employment discrimination and the domestic relations ones, the domestic relations really, one really got subsumed under the various activities around battered women. The shelter picked up some of it. There was an emergency domestic relations legal project that the fund had run, which was picked up by the courts, by the local courts. The employment discrimination one got picked up first by the Washington Lawyers Committee, and then I think by another organization, the name of which I'm forgetting, and I'm afraid nobody's doing it now.
And what were you involved in?
So at first, when I was the staff attorney, I oversaw all of the local providers, the volunteers who were providing that. But my primary job, and the fund found volunteers to handle potentially precedent-setting cases of sex discrimination. So I oversaw the intake for that program, and as well as ultimately the placement of those cases with volunteer lawyers. And also part of that was doing amicus briefs in cases before the Courts of Appeals and the Supreme Court on issues of sex discrimination and related issues. And so I did all that, and then I also, the grants were to monitor the enforcement of the Equal Employment Opportunity laws by the EEOC, the Labor Department, and particularly the Office of Federal Contract Compliance Programs, known as OFCCP, which I'm only explaining to you because it's going to be relevant later.
Okay.
And the Justice Department. And we did that in conjunction with Women Employed, which was a non-legal organization in Chicago, but which organized women around employment issues and had brought a big case against Harris Bank that was really precedent-setting, and in which the Women's Legal Defense Fund found a lawyer for Women Employed, and guess who? That was the National Women's Law Center. So, this is all, everybody was in everybody's business all the time. So the bottom line, I got my legal specialty, my substantive specialty was the employment discrimination side and issues that came out of that. I'll let you ask me some questions because I have just been talking. My career is easy to talk about because it flowed pretty naturally, around women's issues.
So let's hear then about some of what you might call your accomplishments and maybe disappointments in employment law while you were at, is it now called the Partnership for Women and Families?
National Partnership for Women and Families, right. But people refer to it as the Partnership.
The Partnership.
well, my biggest accomplishment was the Family and Medical Leave Act, which I did from soup to nuts. I mean, I was there at the very first meeting with the first member of Congress who wanted to propose some sort of pregnancy or maternity leave law, some sort of federal maternity leave law, because there wasn't one at the time. And I was there at the signing of the Family and Medical Leave Act and the writing of the regs, and I took actually a sabbatical from the partnership in 1996 to work for Bill Clinton's re-election, and my job there was to work on family and medical leave issues, so that was taking it into the electoral space, which I had really never done before. So, and really, in some ways, the intellectual genesis of the Family and Medical Leave Act was the Pregnancy Discrimination Act, which was enacted in 1978 and was one of my very first assignments when I came to work at the then Women's Legal Defense Fund. In fact, my assignment was to stand outside the room where the conference committee between the House and Senate was going to be held and save a place for Judy. And then when I left that, I didn't even know what a conference committee was really, except dim recollections from high school, because they sure don't teach high school civics in law school, and they don't teach legislation, and they didn't then anyway. I then went, you will appreciate this, Judy, my next assignment on the Pregnancy Discrimination Act was to do some research on what was called the Conscience Clause. The Pregnancy Discrimination Act, which ultimately was enacted in '78, so that was just when I started, was prohibits discrimination on the basis of pregnancy in employment. It amends Title VII of the Civil Rights Act in order to do that. And Title VII, of course, already prohibits sex discrimination. You would think that would include pregnancy discrimination, but the Supreme Court had held that it did not. Actually, I'm going to back up even a little bit further. The semester I was at the Law Center, at the Center for Law and Social Policy, one of the assignments, Lois loaned me out to the woman who was arguing the Gilbert case, which was the case in which the Supreme Court held that pregnancy discrimination is not a form of sex discrimination, to do some research for her that she needed for a footnote in a Supreme Court brief. And I crawled around the stacks of the Library of Congress to try to find, because she was looking for legislative history of the Equal Pay Act. The woman was named Ruth Wyand, and she was a lawyer for the Electrical Workers Union. So she was the generation ahead, by significantly ahead, years senior to Judy and Marcia and even me. I'm about 10 years younger than Judy, so just to give you an idea of, and a little less actually than Marcia, who had gone to Penn before me, and I had heard of her, and because she and her husband were both on Law Review, but she was kind of a phenom, but she was already gone by the time I got there. Anyway, and she was unusual, such a smart woman, right? That a woman could be so smart and get on Law Review, that was worth noticing back then. So anyway, so I was involved in the intellectual and legal question and jurisprudential question, really, of whether pregnancy is a form of sex discrimination and how pregnancy should be treated in the workplace from 1975. And I'm just saying this because on top of the personal and professional positives that were many that I got out of doing feminist legal work in my career, there is also a significant intellectual component. Because it was really interesting. It is not it's not totally obvious really how pregnancy should be treated. It certainly wasn't obvious in the 70s whether pregnancy was something special and apart and different. And in fact, it created a huge rift in the women's movement and the women's legal movement in the 80s and 90s, whether pregnancy should be treated differently, and it's closely related to abortion.
Well, what was the riff?
So the rift was, there were some people who felt that pregnancy was special and different, and that there was nothing comparable to it that men experienced, and that therefore you had to have special legal protections for pregnancy. So those were the people who supported, for example, providing requirements to provide maternity leave for women, and nothing comparable for men. And that was contrary to the position, that was essentially the position that the Supreme Court took in the Gilbert case. They said in Gilbert, well, pregnancy there's nothing like it for men. So pregnancy, it is something special and apart, and that since you can't discriminate against a man, you can't deny a man something for being pregnant, but you can deny a woman something for being pregnant. There's no equivalence. You can't say that a woman and a man are comparable for this. If pregnancy is extra and special. Therefore, the Supreme Court said it's okay to discriminate against pregnancy. You can treat it better or you could treat it worse. They didn't say you could treat it better in Gilbert, but they said you could treat it worse. That was in fact the specific holding in Gilbert, that you could treat it worse. So the partnership, the law center, and the people who, the IUE, and the people who had pressed for the Pregnancy Discrimination Act, there was a coalition that Judy was actually quite, Judy Lichtman was quite instrumental in, that formed in '76, right after the Supreme Court decision in Gilbert came down, that to overturn that decision, because it was an interpretation of Title VII of the statute, so it could be overturned by Congress, and that's what the Pregnancy Discrimination Act did. So that whole view is that no, pregnancy is comparable. It's comparable to other temporary disabilities, because you can be pregnant, and it doesn't mean that you're unable to work. It means that you might be unable to work for a period of time, not unlike if you have a heart attack. And there might be a period of weeks, depending on the severity of the heart attack. And of course now, heart attacks are not what they used to be. And so you can be out for a couple days, even, for, have the stents put in, and you're good. A little or a lot of medication. Anyway, so that, and there are people for whom that's all the pregnancy is, literally, that the pregnancy disability is not very long. And so that's comparable to other kinds of disabilities that take you out of, really, disability is even the wrong word, because now we use disability to mean people with, like the Americans with Disabilities Act, people who are unable, who have a disability that allows them to work. They have a condition, but it doesn't mean that they can't work. So that's why we started using the term serious health condition to refer to pregnancy and heart attacks and other things that make you unable to work, but temporarily. It's not and then after you're done with your disability related to childbirth, pregnancy and childbirth, then you might want to stay home with your child, and you should be able to stay home with your child and keep your job. And not only that, but there's nothing to prevent men from being able to stay home with their children. Yes, shocking idea. Similarly, because they're not disabled, so men and women are similarly situated with regard to that aspect of pregnancy and childbirth, and they're similarly situated with regard to their ability to work. during the period of so-called disability. So it just took me a little while to explain that to you, and I've been doing this for 30 years, and it's a complicated topic, and looking at it this way forces you to step outside, I think, it forces you to take a step back and have a broader perspective on what it is that affects somebody as a worker. The perspective is not limited by the lens of gender that we've always had. It's very easy to say, oh, pregnancy is different, we'll treat it specially, because you don't have to take that step back. It's harder for people to take this step back. So that's why I'm saying this. There was a rift, and and why it was intellectually challenging and interesting to sort of figure out a way to do this without allowing pregnancy to be treated worse, which is, of course, what the Supreme Court had done in Gilbert. So I'd worked on the Gilbert case, I'd worked on the Pregnancy Discrimination Act, and then a court in California actually held that the Pregnancy Discrimination Act meant that California's Maternity Leave Act was unlawful because it violated Title VII. So that created this immediate need to come up with some kind of response. The people in Congress originally wanted to have a federal Maternity Leave Act and amend Title VII to allow maternity leave. That would have been contrary to the principles of the Pregnancy Discrimination Act. And so I engaged on, started a campaign sort of to educate people about this, and including the members of Congress. And ultimately, what was introduced and passed over a 9-year lobbying campaign, which I was was the day-to-day head of, was the Family and Medical Leave Act. And it says you get leave for serious health conditions regardless of your gender, and you get leave to care for your family members, including new babies, but also seriously ill children and other family members with serious health conditions. So it carries through that concept. And in the end, had persuaded the special treatment people, for the most part. There were a couple law review articles that I still get annoyed because they're so snippy that were written. But that suggested that maybe we would have done better to just go with maternity leave only and make it paid. And then if it was only for women, we would have been able to get it paid. But of course, now we're working on paid family leave. And
absolutely.
Anyway, so the Family and Medical Leave Act, to answer your question, is, without question, my proudest accomplishment.
Any major disappointments you could point to?
The biggest disappointment is that family and medical leave, sexual harassment, pregnancy discrimination, all of those things. And sexual harassment is a great example. All that work, and they're still so common. And I attribute that to the government's, for the most part, not having done what it really needed to do, not having made it a priority to enforce the laws that prohibit discrimination in employment. It's true of race discrimination as well as these sex discrimination. And it's, you can legislate behavior but not opinions, right? Not the way people think. And when you have such a big economy and so few resources devoted to educating people about what the law is and to enforcing what the law is, you get what we have now, which is these good laws on the books, and large numbers of scofflaws. Most people get away with continuing to discriminate. Many employers that do discriminate, and certainly that harass and abuse employees on the basis of race or sex or religion, etc.
So you left the partnership at some point, and have you continued to be an activist? in women's issues?
Yes, I have broadened my activism so that I'm looking at it more as, have been looking at it more as employment discrimination generally, and employment issues generally, and not just for women, although that's still in many ways, but that's how I've come to these views. So immediately after I left, I was at the National Citizens Coalition for Nursing Home Reform, which is a coalition of groups that work on behalf of nursing home residents, most of whom are women. And that was a bit more of a consumer health perspective, not so much an employment perspective. It's a cause I really believe in, but I missed working on the employment issues. So I ended up going back to them, and then I was the first legislative director for the National Employment Lawyers Association, who are the lawyers who represent women and men who are bringing employment discrimination cases and other kinds of employment cases against their employers. So it's the plaintiff's bar, essentially. And so we worked on all kinds of issues, Title VII issues particularly. It's another disappointment. Arbitration is a huge, forced arbitration is one of the big ways in which people are sort of cheated out of the rights that are on the books because they're not enforced, and they get forced into this uneven playing field. Certainly, instead of going to the EEOC, they have to bring their cases before arbitrators and the deck is stacked against individual employees in arbitration. So, and not having been able to make much of a dent on that is another. I really was, when I was at NELA, as that organization is called, that was one of our biggest priorities. And we got a few things, but so that is one big concern. And then I left NELA after about 4 years there, to go to the OFCCP, that the office in the Labor Department that I had mentioned previously. And there I had a position called Senior Civil Rights Advisor. My colleague from back in the days of working on the Pregnancy Discrimination Act was appointed the director of the OFCCP in the Obama administration, and she brought me in to help her develop policy and implement policy, government policy. And as I said, the government not doing enough is what I think was one of the biggest problems. And I felt like this was an opportunity to really make a difference in that space. While I was there, my major project was to rewrite the sex discrimination guidelines of the OFCCP, which we did, and we updated them to, for example, include the concept of pregnancy discrimination, which wasn't even in those guidelines. We were unable to update the affirmative action requirements for women and people of color in the construction industry. That was probably my biggest disappointment there. It's complicated, so there were good reasons why we weren't able to do it. And I loved working in the government. This was another, to be able to sort of try to move the feminist legal principles and, in general, the equality legal principles within the constraints that the government had was a real challenge. And the people were so good and so thoughtful and so smart. The lawyers were really excellent. I mean, I was surprised. I did not think that necessarily, except maybe the top level of political appointees, that I would be as impressed with the Department of Labor, but I really was, and I loved that job. So after the debacle in 2016, I was a career employee, and I moved to the Department of to the Office of Apprenticeship in the Department of Labor, because I wanted to help them implement their recently redone regulations on equal employment opportunity for apprentices. Most apprentices are in the construction industry, and really the reason I went there was my interest in trying to increase women's representation in that non-traditional sphere, which was something that I'd been involved in way back, since the Women's Legal Defense Fund days. And the Women's Legal Defense Fund and the Law Center both had been involved in a lawsuit, actually that ended up with a requirement that there be that 6.9% of construction workers be women. A requirement that still all these years later has not been met everywhere, in every location. So I really wanted to, gave me an opportunity to work on that. And when I left the Labor Department, I had a contract to continue to do that, and I am still doing that. So I am trying to help the Office of Apprenticeship actually enforce its EEO regs, including ultimately, there is no 6.9% requirement for apprentices, because that's for workers. Apprentices, there is affirmative action required, but that's based not on the number of people who are already available to be construction workers, the percentage of women who are already construction workers, but the goal is based on the percentage of women in the labor pool, in the available labor pool. And since most construction apprenticeship programs only require that you have a high school degree and maybe a driver's license in order to be an apprentice, what's the percentage of women who have a high school degree and a driver's license? It's pretty damn close to 50%. In most places. I mean, it is based on the geography. So that has been my focus for the last 2 years, is that 50% number in my head.
Well, we need to conclude.
Yes.
So we've gone through your involvement from the beginning of your life, basically.
Most certainly my professional life.
Certainly. I don't know, do you have any concluding, looking back statement you want to make, or anything we left out?
Well, I think one thing I want to say is that in addition to the sort of professional and intellectual benefits that I've gotten from being involved in the women's movement, and more limited in the women's legal movement, I've made such really good friends, and it's many of whom I still see, some of whom I don't see often, but when I do, it feels like, we are so much on the same page. We perceive the world in the same way, and there's just a personal aspect to it as well, because people get involved in this because of their belief system, really. I think it's true of any movement. The people in your movement feel like family, and that has been a really nice aspect of having been able to be in this life, which has been great.